Hi, this is Dr. Carpenter. I'd like to thank you for taking the time to join me on today's video. On today's video, I want to go over a very important topic with you, and that is the concept and the topic related to substantial medical evidence. Substantial medical evidence. Now, I find that doctors fall into two basic categories. There's those doctors who are familiar with the term and the concept of substantial medical evidence, and then there's doctors who are not, doctors who have never heard of the phraseology of substantial medical evidence and have no idea as to what constitutes substantial medical evidence in their QME reporting. So I want to talk today about substantial medical evidence, and I want to emphasize the importance of making sure that in every single opinion and every single conclusion that you offer in your QME report, you substantiate that opinion and conclusion in order to make that opinion and conclusion qualify as evidence that the parties qualify as substantial. In other words, your opinions and your conclusions have to be substantial, meaning they have to be substantiable and they have to be substantiated. And many times doctors provide opinions and conclusions in their QME reports that are not substantiated. And the term that's used when opinions and conclusions are not substantiated is the term is called conclusory. Conclusory. And what conclusory means is that the doctor has simply provided a conclusion, an opinion or a conclusion without substantiating it. So let me give you an example of what a conclusory opinion is. Conclusory opinion would be, for example, in my opinion, Mrs. Jones became permanent and stationary on June 14, 2014, period. That is a conclusory opinion. And it's not a substantial opinion, and it doesn't qualify as substantial medical evidence because the doctor does not explain how and why he concludes that that was the permanent and stationary date. You see, it's simply not enough to provide your opinion and conclusion. You have to substantiate your opinion and conclusions with your reasoning as to how and your reasoning as to why. So we want to give you some suggestions and some ideas. First of all, about the concepts of substantial medical evidence. And then number two, some ideas and some suggestions for preparing your QME reports to make sure that when your QME report leaves the office for the mailbox, that you've dotted every I and crossed every T of every opinion and conclusion in your report so that your report indeed does qualify as substantial medical evidence, and that your report will stand up and your opinions and conclusions will be upheld and withheld. Okay, and then at the very end of the program, I want to give you a special gift. It's a little template that you can use to cut and paste into your reports to demonstrate to the parties that indeed you have duly considered all of your opinions and conclusions, and you put by your signature, you put your stamp of approval on each of the opinions and conclusions by yourself personally qualifying each of your opinions and conclusions as substantial medical evidence, and then explaining the reasoning as to how and why you arrive at those conclusions. So I'll have that for you as a special digital download at the end of this brief video. Okay, so let's begin. Now, substantial medical evidence was really solidified recently in the Escobedo case, but substantial medical evidence has been a topic in legal writings going way back. And specific citations that I was able to locate go back as far as even in the 70s and early 80s with the Granado and Zemke cases. But most recently, we rely on the definitions derived from the Escobedo case for our most current recipe. Let's use the word recipe. Recipe for what qualifies and what elements a report needs to persuasively demonstrate in order to qualify as substantial medical evidence. And we'll go over a couple of key citations from the Escobedo case as relates to substantial medical evidence here in just a couple minutes. Now, a little quotation here from the Granado case. The Granado case concluded, and this was, like I said, this one dates back, to 1970. 1970. In Granado, they concluded that a medical report is not substantial evidence unless it sets forth the reasonings behind the physician's opinion, not merely the conclusions. So here's the key word, the reasonings behind the doctor's opinion or the doctor's conclusion. So let me give you just a little bit of heads up as to where we're going. If reasonings are so important, then what we're going to do is after each and every opinion and conclusion that we offer in our report, we're going to follow that up with a paragraph that begins by stating, my reasons for this conclusion include, colon, and then some bullet points down below wherein you elaborate on the reasonings as to how and why you came up with this opinion and conclusion. Because simply conclusions without the reasonings to support those conclusions does not qualify as substantial evidence. And if you don't provide the reasonings behind your opinions and conclusions, your report, they can't use it. It's not substantial medical evidence. It's not substantiated to the point that the parties can rely on those opinions for the resolution of the case in chief. Now, in the Zemke case, and this was a 1980s case, I believe, in the Zemke's case, the important quote for our purposes that came out of the conclusions of the Zemke case was that substantial evidence cannot be based on a legal conclusion that does not furnish a basis for the finding. So we might even use that term in support of our opinion and conclusion. We might say, my basis for this conclusion includes, colon, and then some bullet points underneath to provide the bases upon which you arrive at the conclusion. See, the parties are going to look at your reasonings and they're going to look at your bases in order to determine if you're using correct principles upon which to base your opinion and conclusion. And nowhere is this more important than when we get to our permanent impairment and our apportionment determinations. And there's some specific citations in Escobedo that relate specifically to our permanent impairment and our apportionment determinations. And really the whole Escobedo case itself and the whole en banc decision about the Escobedo case involved the apportionment determination of the evaluating physicians in that case. And there was two evaluating physicians that came up with differing opinions and became a landmark case as relates to proper and correct methods to be used for apportioning the permanent impairment. So let's talk about Escobedo, and then we'll get actually into the actual text of the Escobedo case. In Escobedo, substantial medical evidence was defined as following. Escobedo stated that, number one, an opinion or a conclusion must be framed in terms of reasonable medical probability. Reasonable medical probability. So that gives us a clue. whenever you provide an opinion or a conclusion, one of the bases or one of the reasonings behind your opinion and conclusion is that it's based upon reasonable medical probability. In other words, it means that in your opinion, doctor, in your opinion, this conclusion is more likely than not. It's reasonably medically probable. Probable means 51% or greater. Number two, the opinion and conclusion must not be speculative. Must not be speculative. Must not be based on speculation. Must not be based on guess. Must not be based on conjecture. It must be based on some solid fact, some solid factual, historic, or medical record or physical exam basis. There must be some factual basis for the opinion or conclusion, not simply based on guess, speculation, or conjecture. And I'm sure you're familiar with speculation and conjecture. Many times when people sit around and talk and just chat informally, they talk back and forth about a variety of topics, not all of which are firmly based in anything factual at all. In fact, I frequently talk with my wife about various topics over the dinner table and what have you, and she frequently says to me, well, that's speculative, and I frequently will say to her, well, that's speculative. And it's true. We say a lot of things that are based on speculation, but that does not fly with our QME reports. And anytime there's a hint of speculation or conjecture, that does not qualify as substantial medical evidence. Okay, and I'll show you how you can use the speculation checkpoint when it comes time to check your own QME reporting. Number three, it must be based on pertinent facts. Pertinent and relevant facts. So when you provide your opinion and conclusion, cite the pertinent facts upon which you're basing your opinion. And see, really, this is a valuable exercise for us to go through as evaluating doctors, because it serves as a validity check for ourselves to make sure that, indeed, when we provide our opinions and conclusions, they have some basis. They have some reason behind them. They have some factual basis. And it's a good exercise for us to actually review the factual bases, not only to ourselves, but also to the parties, so that they can indeed see that we're relying on correct principles. Okay? Number four, it must be based on an adequate examination and an adequate history. So always take a good history. Always do a fabulous exam. A fabulous exam. Now let me tell you this. The reader of your report, even a non-medical person, can tell the quality of your examination. Can't you tell the thoroughness of a doctor's examination when you read their physical exam section of their report? Can't you tell what procedures they did, what procedures they didn't do, what procedures were omitted? Can't you tell upon what information in the physical exam they're relying when it comes time to reading the opinions and conclusions? Can't you tell when an opinion or a conclusion does not have adequate basis in the physical exam section? In other words, your physical exam section should support your opinions and conclusions. The pertinent facts of your physical exam lead naturally into your opinions and conclusions. And it's only when your physical exam is fabulous. Fabulous. Did I say fabulous? Your physical exam should be your pride and joy. The physical exam section of your QME report should be a masterpiece of thoroughness, of detail, of meticulous attention to every detail. No physical examination procedure undone, no objective test undone, uncompleted, no measurement left undone, no physical examination procedure fabricated after the fact. Your physical examination should be perfect. You never leave the physical exam with a single objective test undone. Your physical examination section is your representation of your body of work. It should be of something of which you're most proud. Okay? So, and Escobedo even said it must be based on an adequate examination. If you don't have adequate examination findings to support your opinions and conclusions, you're toast. Your QME report is toast. The opinions and conclusions have no value. So, I want you to focus on improving your physical exam. Finally, Escobedo said that for an opinion or a conclusion to qualify as substantial medical evidence, we as the doctors must set forth the reasoning in support of those conclusions. Reasonings in support of those conclusions. Now, it's interesting. Sometimes in this type of work that we do, things are not always black and white. There's many shades of gray, and there's some areas where there is some uncertainty. And many times we cannot be always correct, or we not always 100% right. Sometimes, how do we know when we're right? In the medical business, it's sometimes not possible to be right. In fact, the very word diagnosis has some uncertainty in it. The word gnosis comes from the Greek verb don't know. We don't know. But in the QME report, when you provide an opinion and conclusion, whatever that opinion or conclusion is, even if it's not right, at least be right in being wrong. At least support your opinion, even if it's totally wrong. You can be totally wrong as long as you support your opinion and conclusion. And the parties might look at it and they say, well, that's completely wrong, but that's what the guy believes. But now we know what he believes. We can work with it, even if it's wrong. See, in that sense, you take a stance, either black or white, and it's okay to be wrong, but support your opinion, whatever it is. Okay? Okay, so let's now take a look at the Escobedo case and have it up here on the screen so that you can follow along with me. And I'm not going to beat this point to absolute death, but I want to highlight the key citations in this case that relate to what we're talking about with regards to substantial medical evidence. And in this case, the Escobedo case points particular emphasis towards the permanent impairment determination and then, of course, the apportionment determination. And these are the areas where your opinions and conclusions are most closely scrutinized. That is, your permanent impairment determination and your opinion on the causation of the permanent impairment. So, of course, both of those opinions need to qualify as substantial medical evidence. But the theme of today's program is that all of your opinions and conclusions have to be substantiable. And have to be reasoned and explained as to how and why you came up with your opinion or conclusion. Okay, so Marlene Escobedo was working at Marshall's department store. She suffered a right knee injury, and she had a qualified medical evaluation. And the qualified medical evaluator, the defense qualified medical evaluator, disagreed with the primary treating physician. The primary treating physician provided a permanent impairment opinion, but did not apportion any of the permanent impairment to pre-existing degenerative arthritis of the knees. And Marlene Escobedo was found to have permanent impairment of both knees. Well, the defense filed a petition for reconsideration, and what they based their petition on was they claimed that the qualified medical evaluation the applicant attorney filed for a petition, and he stated that the QME's opinion that the applicant's pre-existing arthritis contributed to part of the permanent impairment. He claimed that his argument did not constitute substantial medical evidence because it failed to explain in adequate detail how the pre-existing degenerative change caused permanent disability. So that sort of sets the framework for where we're going. So in this case, we're dealing with substantial medical evidence as it relates to the apportionment of the permanent impairment. So let me pick out some of the key citations from the Escobedo case. It said that apportionment of permanent disability caused by other factors is possible provided that there's substantial medical evidence establishing that these other factors have caused permanent disability. So with regards to the apportionment determination, any opinion that you render must be substantial, and we'll talk about the factors that contribute to substantial medical evidence. They concluded that even where a medical report addresses the issue of causation of the permanent disability, and even though you do make an apportionment determination according to Labor Code 4663A, the report may not be relied upon, and maybe this should say cannot be relied upon, but they say that the report may not be relied upon unless it also constitutes substantial medical evidence. Okay, so we're developing our theme that one of these two doctors who opined in Marlene Escobedo's case provided an opinion that was substantial and the other one did not, and the one with the more substantial opinion is the one that prevailed in this now landmark case. Okay, so scrolling through just to get to our point. They stated that if the reporting physicians disagree, and in this case we had two reporting physicians, both of whom they disagreed with each other, they disagree regarding the overall level of permanent disability and or regarding the approximate percentages of industrial and non-industrially caused permanent disability, then the board or the judge must weigh the evidence appropriately and determine these issues based on the most persuasive, substantial medical evidence. And the whole purpose of this video is to arm you with the tools that you need so that when it comes to these difficult determinations, yours is the report that becomes the most persuasive and the most substantial. Now, here's a key quotation from the Escobedo case. They state that the criteria that a medical opinion must meet in order to constitute substantial evidence on the issue, number one, of permanent disability, and number two, on the issue of causation of the permanent disability. We're going to get to those criteria below, but they specifically state here that these criteria relate to permanent disability and to the causation/apportionment of the permanent disability. So I'm going to give you some key phraseology that you can cut and paste into your report after your permanent impairment and after your causation sections in your report, where you can summarize those two sections and demonstrate to the parties that your opinion on both topics are substantial. Okay, so let's come to the conclusion of the Escobedo case, at least with regards to substantial medical evidence. If a report addresses permanent disability and the causation of it. Still, the report may not be relied upon unless it constitutes substantial medical evidence. All reports and decisions must be supported by substantial evidence. So here comes our criteria. It's been long established that in order to constitute substantial evidence, a medical opinion must be predicated on reasonable medical probability. And that goes back all the way to the beginning of time, even with cases in 1968, 1949, 1993, etc. Also, a medical opinion is not substantial if it is based on facts no longer germane, on inadequate medical histories or examinations, on incorrect legal theories, or on surmise, speculation, conjecture, or guess. And there's the Zemke case that I referred to earlier. The Granado case concluded that a medical report is not substantial evidence unless it sets forth the reasoning behind the physician's opinion, not merely his or her conclusions. So really, we take our recipe for substantial medical evidence right out of these sections here. And I'll summarize those for you in just a second. Finally, they state that the chief value of an expert's testimony rests upon the material from which his or her opinion is fashioned, and the reasoning by which he or she progresses from the material to the conclusion. And you need to demonstrate that to the parties, doctors. You need to demonstrate your reasoning, and you need to demonstrate your progression all the way to the conclusion. And it does not lie in the mere expression of the conclusion. Thus, the opinion of an expert is no better than the reasons upon which it is based. Remember, we said that the mere expression of the conclusion, we refer to that as conclusory. In the context of apportionment determinations, the medical opinion must disclose familiarity with the concepts of apportionment. It should describe in detail the exact nature of the apportionable disability. It must set forth the basis for the opinion. That way, when you do those things, when you describe in detail and when you set forth your basis, the board can then determine whether or not you're properly apportioning under correct legal principles. If you don't detail this out and describe this out in advance, they have no way of knowing how you arrived at your conclusion and whether it's based upon correct legal principles. So finally, with regards to apportionment, in order to qualify as substantial medical evidence, a medical opinion must be framed in terms of reasonable medical probability. It must not be speculative. It must be based on pertinent facts and on an adequate examination and history. And it must set forth reasoning in support of its conclusions. Basically, it needs to explain how and why, in this case, with regards to apportionment, how and why the disability is causally related to the industrial injury, and how and why, let's highlight that, how and why the injury is responsible for some other portion of the disability. How and why are our key phrases. So in this case, they found that the defense doctor who opined that 50% of the permanent impairment was due to the pre-existing degenerative arthritis of the knees, they found that his opinion qualified as the more substantial of the two opinions, and his finding for approximately 50% of the permanent disability was held up. Okay, doctors, so that's the Marlene Escobedo case. Let's summarize this, and let me give you some tools that you can use in your very next QME report. So I have here open a QME report template, And this is a female template. And you see that I've opened my template to the permanent impairment section of the report. And in this section, I have all of the permanent impairments set up both under the old system and under the AMA Guides 5th edition. And so let's just scroll through this here. You'll notice that I have all of the DRE and all of the range of motion method spinal impairments already set up in here. Have impairments for all regions of the spine already set up here. Here's the range of motion method. It's already set up. All the upper extremity impairments are already set up. All the lower extremity impairments are set up. I have a comparison table here for providing for either upper or lower extremity permanent impairments by analogy to the other extremity. In other words, providing for upper extremity impairments by analogy to lower extremity impairments. Permanent impairments due to work restrictions, loss of pre-injury capacity if we're using the 1997 permanent disability rating schedule. And anyway, so this section would simply be completed with information specific to the examinee. And then we get into the apportionment determination, which it looks like my apportionment section here has gotten a little bit abused. Let's see if we can fix this. Let's see if we can fix this. Go down to our apportionment determination. Yeah, there it is. Okay. And I'll show you how we do the apportionment determination. Okay, so here is the apportionment, and let's call this the causation / apportionment of the permanent impairment section of our report. Okay, so this section is already set up. I have the labor codes 4663 and 4664 set up here for my reference. And so anyway, you make your apportionment determination, and whatever it is, whatever your opinion is in the very end in this section, you conclude these two sections, the permanent impairment section and the causation / apportionment of the permanent impairment section, with your statement of substantial medical evidence. And this is the same criterion as we described earlier, but here you see how it's cut and pasted into your report. So let's simply go through this one more time to solidify this concept. You state here that the above opinions on permanent impairment and the causation / apportionment of the permanent impairment, and that's exactly the way it was described in Escobedo, both permanent impairment and the apportionment determinations have to qualify or constitute substantial medical evidence. So here's where you tell the parties that the above opinions are based on reasonable medical probability, not certainty, but probability, and my professional experience. And let me highlight that for you. Probability means greater than 51% chance of occurrence. It's based on an adequate history as provided in the medical records and is clarified by Mrs. Jones. It's based on my physical examination of Mrs. Jones on 1/1/2010, 2/13/2013, and 1/29/2015. If you saw Mrs. Jones on 3 separate occasions, you would fill in those dates right here. Your opinion is based upon review of the available diagnostic studies. It's based on medical research into the findings of the diagnostic studies, if that statement applies to you. If not, you would simply highlight that and delete it from your statement. and any follow-up consultation that you might have with a medical radiologist, electrodiagnostic testing technician, or interpreting physician, or any other consultation, you would fill that in right here. And then finally, you need to review your opinion and make sure that none of your opinions are based upon anything related to speculation, conjecture, surmise, or guessing. And compare your opinions against these criteria. Only when your opinions are satisfied by each of these criteria, or in other words, only when your opinions satisfy these criteria is your report ready for your signature. So doctors, when you add this statement of substantial medical evidence to your reporting, it makes your reporting so much more powerful in a couple of different ways. First of all, it indicates to the parties that you're familiar with what substantial medical evidence is, that you're familiar with Escobedo and the standards that are espoused by Escobedo, and also because it allows you to serve as a check and balance system against which you compare your report to make sure to your own satisfaction that indeed your report meets all of these criteria. And if you yourself are not comfortable that your report meets these criteria, then certainly your report is not ready to be sent out. Now, let me just say one more thing before we conclude this program. If you've ever been in deposition, the reason that you're at deposition is because one or more of the parties have some disagreement over one or more of your determinations, and that typically falls upon your determinations for permanent impairment and or the causation / apportionment of the permanent impairment. I mean, those are the two basic money categories of your report. And if you're called to deposition, it's because somebody has some disagreement with one or more of your opinions. And one of the ways that the parties will try to either verify or reinforce your opinion, or to negate or tear down your opinion, is by demonstrating to the trier of fact, meaning the judge, that your opinions are not substantial medical evidence. So, for example, if you have an attorney who wants to try and help support your opinion or help defend your opinion, in other words, he's happy with your opinions, he may try to demonstrate that indeed your conclusions are substantial. So that line of questioning could go as follows. Doctor, did you take a history from Mrs. Jones during your face-to-face evaluation? Your answer would be, yes, I did. What's he trying to do there? He's trying to demonstrate that your opinion is based on an adequate history. The attorney may ask you, Doctor, did you do a physical examination of Mrs. Jones on 1/29/2015 during your qualified medical evaluation? Your answer to that would be, yes, I did do a physical examination. What's he trying to demonstrate? He's trying to demonstrate that your opinion is based upon an adequate physical examination. He may ask you, Doctor, did you review any available diagnostic studies? Your answer would be yes, and he would follow that up and say, well, tell me what you reviewed. And you'll tell him, and he'll ask you, did you have a chance to review the June 24th, 2011 MRI studies? And you can simply say, well, yes, I did, if you did. And what's the strategy behind this line of questioning? It's to demonstrate that your opinion is based upon a review of the available diagnostic studies. They may ask you, Doctor, did you have any follow-up consultations? You can say, yes, I did. They can ask you, Doctor, is any part of your opinion based upon speculation or conjecture? If so, which of those opinions are? And you simply would say, no, none of my opinions are based on speculation or conjecture. They're all based upon reasonable medical probability and my professional experience. And in that situation, the attorney is attempting to qualify your opinions and your conclusions as substantial medical evidence. Now, you can expect it to go in the other direction as well if one of the parties disagrees with your opinions and conclusions, and they may try to find loopholes in your opinions and conclusions to demonstrate that, in fact, your opinions and conclusions do not qualify as substantial medical evidence. So, doctor, make sure you never, ever, ever send out your report signed if your report does not satisfy these 5 criteria to the point that you are comfortable being called to deposition if one or more of the parties should disagree with your opinions and conclusions. So, doctors, I hope this helps you. The purpose of this program and the purpose of all the continuing education home study programs that we provide for you are to help you to become a better qualified medical evaluator and to produce better qualified medical evaluation reports. You know, really, it's our qualified medical evaluation reports that serve as the representative of us. It represents our body of work. And so I'm encouraging you to improve the quality and the content of your QME report. And as we talked about in this program, nothing does that more than a masterful physical examination. And indeed, the physical examination is going to many times provide the basis upon which you rely for your opinions and conclusions. And the physical examination is our exclusive domain as doctors. And so really, the physical examination section should be a masterpiece. It should be a stellar representation of your attention to detail and your meticulous examination procedures. So I'm encouraging you to ramp up your physical examination procedure. And then once that's established, making sure that all of the opinions and conclusions that you offer throughout your report, not just in the permanent impairment or apportionment sections of your report, but really throughout the entirety of your report, you want to make sure that every opinion and every conclusion is supported with a how and why. And I gave you several ideas as to how you can do that. You can simply provide a paragraph below each opinion and conclusion and state that my opinion on such and such, my reasoning for this opinion is based upon colon, and then list a series of bullet points wherein you detail how it was that you arrived at that opinion or conclusion. And as I said, you could be completely wrong. But if you arrived at that opinion or conclusion in a right way, at least you're right in being wrong. That's all the parties want, is they want to know what's your position, what's your stance, and is your stance substantial. They can do a lot more with a wrong opinion than they can do with an opinion that really has no basis and is not substantial medical evidence. So nothing demonstrates more to the parties that you've considered every possible factor than by cross-checking your own report against the criteria as elaborated in the Escobedo case to ensure that indeed your report qualifies as substantial medical evidence. So doctors, I hope this has been helpful for you. I want to thank you for joining me on today's video, and I look forward to being with you on future videos. For now, I'm wishing you best of success in your career as a qualified medical evaluator.